Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I rise tonight at adjournment proceedings to pursue a question I initially asked on April 30th. Tragically, and I do believe it's a tragedy for this country, the subject of my question, the so-called Anti-Terrorism Act, Bill C-51, has now passed this House under time allocation, pushed through without adequate study, and has also been passed in the Senate of this country, where I do believe the Senate has a role for a sober second thought and should have put forward amendments, and those amendments should have come back to the House for further consideration. But as it happens, my opportunity to pursue the question that I asked on April 30th comes today, on June 16th. So I will pursue it in the interest of public education and perhaps even in the education of members opposite. The critical issue, and there are many before us in Bill C-51, the infringement on our civil liberties while simultaneously making us less safe, less able to anticipate, interrupt, and prevent terrorist attacks. A bill that makes us less safe while destroying our Charter of Rights and Freedoms is quite an accomplishment, if one takes a dark view of things. But the question I asked back on April 30th related in a very straightforward fashion with terminology used by the Minister of Public Safety. There's been an attempt throughout the sales job for Bill C-51 to tell us that it includes the concept of oversight. Moreover, the Minister for Public Safety has claimed it includes judicial oversight. In fact, it includes no such thing. And so with the time remaining, Mr. Speaker, I hope to set out what I've learned about judicial oversight, about review, and about warrant provisions from many expert witnesses who testified before the House and the Senate, and drawing, of course, on my own background as a practicing lawyer. The reality is, Canada has no parliamentary oversight of security operations, no actual oversight of any security operations, and less review than any other country within our Five Eyes partners. Now, the question I asked on April 30th was answered, or at least responded to, by the government House leader, who said that, quote, "We chose to have judges review these matters rather than politicians." He claims that there is judicial oversight because there's a requirement for a CSIS agent under Part 4 of the bill to get a warrant from a federal court judge before breaking our domestic laws or violating our charter rights. It's an extraordinary provision. Legal experts such as Professor Craig Forces, Professor Kent Roach, described that provision in Part 4 as a, quote, warrant for constitutional breach, close quote. It's unheard of in any democracy around the world to be able to go to a judge, a federal court judge, in a private hearing, a secret hearing, where no public advocates, such as special advocates that we have in the case of security certificates, no public interest representation is in the room, but the CSIS agents, a federal court judge, and a demand for a warrant. Now, what are these various terms? Review is what the Security Intelligence Review Committee does. It's a series of people, part-time, who meet infrequently to review what's already happened. In the case of the Canadian Border Services, they don't have review oversight. The RCMP has a Public Complaints Commission that allows complaints to be heard, but no actual oversight. And CSEC, the Canadian Security Intelligence Commission, has no oversight or review. So here we are, Mr. Speaker, where an expert on security from the UK, Joe Fogarty, an MI5 agent, spoke in the Senate and said, when asked by his UK colleagues what would they copy in the UK from the Canadian security system, he said, I would urge they not copy a single thing, because Canada's security system is a disaster waiting to happen.
The Honourable Parliamentary Secretary to the Minister of Transport.
Thank you, Mr. Speaker. I'd like to thank the Honourable Member for allowing me to clarify some important matters regarding Bill C-51 and the changes it brings to the CSIS Act, a piece of legislation I would encourage that member and all members to be supporting. Mr. Speaker, now as the members of this House are aware, Bill C-51 gives CSIS a clear new mandate to disrupt threats to the security of Canada at home and abroad. This mandate includes a number of safeguards to ensure that CSIS operations respect the rule of law and the Charter. For example, the bill sets out that all measures taken against threats to the security of Canada be reasonable and proportional in the circumstances. And before CSIS can take any measure that would normally be contrary to Canadian law or that would affect charter rights, CSIS will have to obtain a court warrant. The warrant process for threat disruption in Bill C-51 is built closely on the existing CSIS warrant system. This system has successfully protected the rights of Canadians since CSIS's creation in 1984. The honourable member has stated that issuing warrants is not the same as judicial oversight. We respectfully disagree. The honourable member may not be aware of just how much information is put before judges when CSIS applies for a warrant. Judges receive extensive documentation describing the threat to the security of Canada and exactly how CSIS proposes to address that threat. They can then ask questions and place any conditions on CSIS they deem to be in the public interest. For these reasons, Mr. Speaker, the warrant process is an effective and time-tested form of judicial oversight. It gives impartial legal experts, not politicians, the final decision on sensitive CSIS operations. I would note that the safeguards set out in Bill C-51 go beyond those placed on many allied intelligence services. Not every country has a stringent system of court warrants for intelligence work. I would also remind members that all CSIS operations remain subject to review by the Security Intelligence Review Committee, or CIRC. Indeed, the recent budget doubled CIRC's resources, giving it the means to keep on top of CSIS's new and existing mandates. Bill C-51 also creates specific new reporting requirements for CIRC that will ensure Parliament is kept apprised of the disruptive activities that may be undertaken by CSIS. The combination of independent review and judicial oversight in Bill C-51 will make certain that CSIS uses its new mandate in a lawful and responsible manner. Mr. Speaker, thank you.
The honourable member for Saanich Gulf Islands.
I would urge any honourable member of this place who's genuinely interested in understanding what oversight means to read the hundreds of pages of legal evidence prepared by Professors Forces and Kent Roach, which makes it abundantly clear that, with all due respect to my colleague, Parliamentary Secretary for Transport, of course this isn't his file, but there is absolutely no connection between granting a warrant and judicial oversight. It's like saying, look here, she's demanding we provide a horse, but we've got this perfectly adequate pig over here. We are talking about different species of activities. There is no connection. There is no overlap. We are talking about apples and oranges, and they are relying on apples. But what we need is oversight. We need to also ensure pinnacle oversight. So as the former Chief Justice of our Supreme Court, John Major, who headed the Air India inquiry, said, this bill should not be passed without a security advisor to the Prime Minister, a national security advisor, to be sure that the RCMP tells CSIS what it's doing, that CSIS tells the RCMP what it's doing, and in this whole mess, that somebody has oversight, because right now we have the weakest review and the weakest oversight of any country in the Five Eyes.
The Honourable Parliamentary Secretary to the Minister of Transport.
With that member over there. Mr. Speaker, what is clear is that jihadi terrorists have declared war on Canada, and our government has acted to ensure the safety and security of Canadians. Oversight and independent review are key safeguards that together will ensure that CSIS takes appropriate action against threats to the security of Canada. The bill will require CSIS to get a court warrant whenever it needs special authorities to disrupt a threat to the security of Canada. In this way, the courts will provide independent judicial oversight of CSIS operations. In addition, CSIS activities will remain subject to independent review. Mr. Speaker, with the robust safeguards in the proposed legislation, Canadians can continue to rely on CSIS to protect our national security in a manner consistent with the law and with Canadian values. We take seriously, Mr. Speaker, the first priority of a government, and that is to protect its citizens and maintain public security. Thank you.